Quick determinations may deny many applying for legal immigration status their day in court. This is Dr. David Deschine for a special Saving America report. While my regular audience knows that I'm a harsh critic of illegal immigration, I believe most know that I'm an equally vigorous advocate for legal immigration. Many developed countries, including the U.S., are not replacing their population. This is leading to a shortage of labor. In fact, many advocates of allowing illegal immigrants to stay in America cite the shortage of labor. We need labor to replace our aging population at work and, in fact, to take care of our aging population. Certainly, we do not need more people coming here for handouts. We have enough of those folks already. We also need highly skilled laborers, which I'll address separately. The first issue is that many people are in the U.S. through legal channels and have followed the rules. While some citizens may express concern regarding how some immigration programs were run, the fact is that many followed whatever rules that were there for the specific situation. Many of these legal immigrants have attorneys and court dates. Here in Houston, a very international city, there are many such immigrants and attorneys helping them. This is what we want, an orderly process to review persons for the serious subject of citizenship. In my opinion, we make the process of obtaining legal status unduly complicated for most. Again, I do want everyone seeking legal status to be properly vetted. However, the process often is entirely cumbersome and may discourage our best prospects from seeking citizenship here. The new Department of Justice interim final rule about how the Board of Immigration Appeals, also known as BIA, hearing process will work, and this is a major game changer. The BIA is the highest administrative appellate body in the U.S. immigration system. By definition, the BIA reviews decisions by lower immigration proceedings around the country. The idea is fairness and consistency. The new rule, which will go into effect in early March 2026, is a major reset. For many with a legitimate appeal, they will face summary dismissal instead of a hearing with the BIA. Here is a quick summary of the new rules. Appeal deadlines reduced from 30 days to 10 days. Even with the most diligent attorney, this could be hard to meet. Summary dismissal will be the normal outcome, not the exception. This means appeals can now be dismissed for technical reasons tied to notice language or formatting, even when the underlying case raises serious legal or factual errors. A reasoned review would then not be available. Full briefing is eliminated in most cases, so formal legal arguments may never get before the BIA for their review. Summary dismissal is a final action. If the BIA summarily dismisses an appeal, then the only option is federal court review, a process that is far more complex. What's the justification? Justification for this action by the Department of Justice is to clear a huge backlog and make things more efficient. This reminds me of my own issues with DOJ. We must trim government, which includes our incredibly inefficient court system. However, there is the hammer approach and the scalpel approach. DOJ was ultimately too sloppy to produce the results the American people need. The BIA reform looks like the same bumbling approach. Who is impacted by this change? I asked my favorite immigration attorney this question. She replied that immigrants in the immigration court proceedings are given an opportunity to defend their removal from the U.S. under certain laws found in the Immigration and Nationality Act. That would include asylum, cancellation of removal, and withholding of removal under the Convention Against Torture. Again, people in this status have already been vetted for any criminal behavior. She highlighted the changes above, especially the presumption of denial of the application and then only 10 days to bring the appeal. However, with about 226,000 cases pending for BIA review, there is no practical way for BIA to complete these in a timely manner with the limited resources available. She volunteered that the chances of success for immigrants at the appeals level went from 10% to 1/100th%. This also raises ethical issues for immigration attorneys in terms of taking cases if the likelihood of timely success is so low. She also mentioned that there is a significant shortage of immigration judges already. My suggestion goes back over a year. There are many retired judges and attorneys who would like to do something on a part-time basis to help their communities. Why not hire them at modest hourly pay without other benefits, give them a crash course in immigration law rules, and give those immigrants who are eligible their review opportunity? My second concern is the sudden crackdown on H-1B visas. The idea of these visas is that we do not have enough highly skilled workers in technology and medical research. So, subject to proof that there are not enough domestic workers in certain areas, employers can hire foreign workers under the H-1B process. Employers are required to prove that they cannot hire enough domestic workers for the same pay and benefits. I agree with the premise of President Trump's crackdown. The process is being abused and foreign workers are being recruited in large numbers and paid lower wages than the available domestic workers. His remedy: implement a $100,000 fee for hiring an H-1B visa employee. However, that's the wrong approach. This is the proverbial throwing the baby out with the bathwater. There are clear rules for the use and enforcement of H-1B visas. I propose that the federal employees charged with the audit responsibilities do their jobs. In a quick review, the thousands of foreign workers serving Silicon Valley tech companies often are not meeting the legitimate H-1B standards, especially with regard to pay. The remedy is to simply enforce the rules. On the other hand, we're not producing sufficient numbers of top research scientists to help America and the world conquer cancer, Alzheimer's, and to meet other urgent needs. The H-1B visa process, administered correctly, can help America to continue to be the leader in such important areas. This is Dr. David D. Shine. Thanks for joining me for this special edition of Saving America. Remember, a new Saving America show is aired on the Brushwood Media Network every Saturday at 11 a.m. Eastern Time. Listen on any of the 16 network stations: Apple or Google mobile app, Apple CarPlay, TuneIn, Smart Speaker, and all smart TVs. Find more information at thebrushwoodmedianetwork.com. Please be sure to join us each week. We welcome and love your feedback from our growing audience.